please welcome Professor Stephen McAllister.
Well, it's a great pleasure for me to be here. I don't think I've been with this group before. I have been in this club, in this building, when I was dean, certainly. But I'd like to talk about the Supreme Court in particular today, to a great extent, what the passing of Justice Scalia means. And I want to start, though, before we jump into the controversy, I would like to, if I can get the computer to cooperate, just give you a quick tour of the Supreme Court. And in doing that, I will be able to describe how it works and how it actually decides cases. Because I think that's important to understand. What does it mean when a Justice Scalia passes away? How does that affect the court? And you have to understand in part the way they work together. So let me see if I can get this tour. You go to this OYE site. It's been around for quite a while. Chicago-Kent College of Law sponsoring it. Has lots of stuff about the court. There we go. Lots of stuff about the court, but in particular, I like to show people the virtual tour of the court. So this would be the court as you're walking up towards it. It's right across the street from the Capitol. And unfortunately, you can no longer walk up the steps and go in the door. They have closed the front entrance for security reasons the last several years. So you actually have to go around the steps on the side underneath to get in the building. Those are the front doors. It's a magnificent building built in the Depression era. Sorry, the pictures are not very big. But actually built, and it was not until Chief Justice Taft, who was a former president, that the court actually got its own building. So the first 150 years of the court, they were kind of moved around. If you visited the Capitol, you may have seen the old Senate chamber where they sat for many years. They've sat in New York, Philadelphia, various places. But Taft was actually a politician who understood how to get money from Congress. So he got money for a building, and they built it in the Depression era. So that actually one of the few federal government projects where the money was appropriated, they built the project, and they gave money back to Congress because they had not used it all. So in spite of that, this is all marble, American white oak, very elaborate. This is the Great Hall. So what I'm going to take you is if you walked up the steps and in the front door, this is where you would be. The Great Hall, and you can't see them very well, but in between many of these pillars are busts of the Chief Justices over time. But let's go on to the courtroom, which is more, oops. There we go. So that's the actual entrance to the courtroom. There we go. So that's the courtroom. When you're facing the bench, and again, it's kind of small, so I apologize for that, but you can see 3, 3, 3, the 9 chairs. This is a lectern. It's probably from me to Jim to the bench. You're very close to the justices, and it's a curved bench because they found when they had a straight bench, they couldn't tell who was going to talk when, couldn't see each other. So they have actually curved the bench, but they would sit with the Chief Justice always in the middle, and then it's a seniority system. So on his right is the most senior, on his left the second most senior, third most, fourth, back and forth, until the junior justice is always over here on the far right as you're looking at the bench. When Justice Scalia died, he was the senior justice, so he was sitting right here. After his death for the first session, they draped the chair with black. You may have seen the pictures. But after that first session, they shuffled everybody. So right now, there's an empty chair, and that's something we will talk about. Other things in the courtroom, I don't know if I can really show you. Yeah, so this is looking from the side of the bench. There we go. So the bench with the justices There's council tables up front, and then there's kind of pillars and benches on either side. Actually, on the left is the press, where they sit if they show up. On the other side is the justice's personal guests, and that's done by seniority. So the Chief Justice gets the front row closest to the bench, the Junior Justice gets the back row farthest from the bench. The courtroom is the only part that's public that we can really see, but I want to take you to. So this is the actual conference room. It's got 9 chairs, the chief at one end, the most senior justice at the other. The others all slotted by seniority. And so this is, I want to talk just a little bit about how the court decides cases. There's virtually no case that the Supreme Court has to take. There used to be cases that under statute they were required to decide. That's rare today, it happens occasionally, but for the most part they choose. So that's one reason I think the court is very influential, potentially, and important, also viewed as political at times. They choose which cases they hear. They get about 9,000 requests a year, and for the last 15 years or so, maybe even a little longer, they've been deciding 65 to 75 cases. So the odds are slim that they'll take your case, and they have absolute discretion in deciding which cases they take. Once they take them, the parties brief them. The public part is that courtroom we just saw is the argument, an hour per side, 30 minutes for each, or an hour per case, 30 minutes for each side. And then the justices will retreat to this conference room, which is right behind the courtroom. And no one, when they're meeting, no one is allowed in there except the 9 of them. So if you want to know what goes on in the conference room, the only people who actually know are the justices themselves. No law clerk, no staffers, nobody else allowed in that room when they're meeting. So if there's a message or they need something, the junior justice is the doorkeeper, has to get up, open the door, send out a message if they want something. But what will happen is after they hear those oral arguments, they will, within a couple of days, go into this conference room and they'll vote on the cases. And the justices are very, very different than, say, the White House or Congress. They don't meet before they hear an argument in a case. They don't get together and sort of informally chat about these things. It's a very formal, independent process. Often described as each justice is his or her own little law firm. They operate independently of each other, and I can say my experience as a law clerk, it was rare. It could happen, but it was rare that one justice would walk down the hall to another's chambers and talk about a case. For the most part, they operate independently, so when they come in here, the way it starts is the chief says, here's the Texas abortion case, for example. And the Fifth Circuit said this, and I am going to vote to affirm. Here's my reasons. Then the next most senior justice does the same thing, and they go around the table and count up the votes and decide the tentative vote is whatever it is, 5-3 in that case. And then they will start the process of writing an opinion. If the chief's in the majority, he assigns opinions. If he's not, then the most senior justice will assign the opinion, and nowadays that's often going to be either Justice Ginsburg or Justice Kennedy, most likely. So then after they've voted, the opinions will circulate. That can take months, depending on the case and how many people want to write and what they want to say about it. But those work their way around. They literally used to be just walked around paper copies. The court has advanced technologically somewhat since I was there. But over time, they'll work that out, and then they'll come back in the courtroom one day. They don't tell you, they tell you days they'll be in the courtroom, but they never tell you in advance what they're going to decide, and then they will announce the opinion. So Justice Scalia, for the last several years, would have been sitting at the end of the table opposite the chief as the most senior. He would have always been the second person to vote in recent years, and obviously very influential. So understand it's a very, if you will, intimate process. It's 9 of them, and they do have support staff, law clerks and others who help them with things, but they sit around that table, just the 9 of them. They explain what they're going to vote and why. Then after that, the law clerks will be more involved helping write opinions and so forth. But think about that, if there's just 9, and particularly a powerful presence like Justice Scalia is suddenly gone, it makes a big difference in the dynamic. Just in the court, my old boss, Justice White, always said every time there's a new justice, it's a new court. So even though 8 of us are the same, there's somebody, it's such a small group, a different person makes the whole thing feel different. And so right now, they're in kind of a limbo. It's definitely a different court, but they don't have a 9th. So let me talk about that, if I can get back to the PowerPoint. Okay. So that's just by way of trying to understand, I think I can do without this now, a little bit how the court works and why one individual can be awfully influential. Well, let's see if I can, no, there we go. So when we started last October, these were our 9. So you're probably familiar with them. Again, everything in the court seniority. So the chief sits in the middle of the front row, Scalia to his right is most senior, Kennedy to his left is next most, then Thomas, Ginsburg, Breyer, Alito, Sotomayor, and Kagan. There's a method to all of this. So that's our 9 when we start, and what kinds of things are on the agenda this past term. Abortion, the Texas case, a big case. Affirmative action, another Texas case, the Fisher case, which had been to the court once before and came back. Death penalty, I put up there for 2 reasons. One, Kansas had 3 death penalty cases that went to the Supreme Court, and we won all 3. And I'll talk about who wrote that opinion and what he had to say. But also because Justice Breyer and Justice Ginsburg have started agitating a bit to question whether we should have the death penalty at all. So when I was there, that was what Justice Marshall and Justice Brennan always said, it's unconstitutional in all circumstances. There hasn't been anybody to say that since Marshall and Brennan left the court 25 years ago, but now Breyer and Ginsburg are starting to say, maybe we should consider whether we allow the death penalty at all in this country. So I think in the future, it may well become a bigger issue at the court. Executive power, another Texas case. Texas was playing a big role this year. The immigration case, so the president's executive order on immigration, which would allow something like 4 million people otherwise deportable to be protected, primarily parents who were illegal but who've had children in the U.S. since they've come here, so the children are citizens, but the parents are not. And the order also allowed some work authorization for that same group. Texas and 26 states, including Kansas, challenged that, saying the president doesn't have the power to do it. So we'll talk about that one. There are always issues of federal versus state power, something I'm sensitive to, and as a Kansas Solicitor General, we are often pushing back, arguing the federal government's getting in our business, intruding on our territory, trying to protect the state's prerogatives. Religious rights are often in play. I'm going to talk about that. Certainly the health care law has brought a lot of challenges to the front as there are religious objectors to requirements of that law and whether the federal government has to accommodate them. And then there was a big case potentially on public unions and free speech. To what extent could unions effectively compel dues from people who objected to the messages and the political positions of the unions, but they were within the group of people the unions were typically representing. So those were all, whoops, going the wrong way, on the docket. None of them
decided except for the death penalty cases before Justice Scalia passed away on February 13th. And there's the justice being very demonstrative, as he often was. That's the way the bench looked the first session after he died. They draped the front with black and they draped his chair. I will say about Justice Scalia, I knew him for 27 years, taught with him, had him visit KU a couple of times, argued in front of him several times, was around him as a law clerk. A wonderful, wonderful person, very strong views, very articulate. Scalia, one thing about Scalia, I talked about the law clerks helping draft opinions. You can read a lot of Scalia opinions and know he wrote those words, because no law clerk would dare say some of the things that he would say in an opinion. We wouldn't have been brave enough to do that. So that's him talking. But he was also a very social and entertaining character. People loved him at gatherings and so forth. He had all sorts of stories, great sense of humor. One of his favorite things that we got to do with him was, when your law clerk's there's 4 per justice typically. And one thing you can do is, so I work for Justice White. Well, we can invite Justice Kennedy or Justice Stevens at that time or Justice Scalia to go to lunch with just the 4 of us. And they would accept those invitations and we'd take them out to lunch. Scalia loved to go to an old rundown Italian restaurant on New York Avenue called AV Ristorante. And it was great because you didn't really have to do anything. You just went with him. He ordered the anchovy pizza. So you either liked it or pretended like you liked it. And then he would order wine. And this was at lunchtime. He's the only justice, I think, who ordered alcohol when we took them to lunch. And then he would go to the jukebox, which was loaded with opera music. And he would put in I don't know what it is, I don't know much about it, but so he'd sit there eating anchovy pizza, drinking wine, listening to opera while regaling us with stories. I mean, he's just a wonderful, wonderful person and very powerful. So I think, when he passes away, well, what happens then to all these controversial issues that are pending? I will say, for the most part, from a conservative perspective or from what you would think Justice Scalia would do, things went south. They most all went in the wrong direction. The abortion case, Kennedy actually joins the majority, and I'm beginning to wonder if we're seeing Justice Kennedy transforming from a conservative to moderate on some issues to more a moderate to liberal on virtually everything now. That maybe he thinks his legacy is better. He's going to be remembered longer if he keeps expanding rights rather than if he takes more conservative positions. So he's actually in the majority on abortion, striking down the Texas requirements that doctors who perform the abortions have admitting privileges at nearby hospitals, and that the facilities have to meet what are called ambulatory surgical center standards. So the court struck both those down. Affirmative action, the Fisher case, is kind of weird because it drops down to 7 justices. Justice Kagan was recused. She had some involvement with it when she was in the USSG's office, so she's out. So it was 8, and then Scalia dies, it's down to 7. But again, who goes to the majority to uphold the UT program? Justice Kennedy is the one. And Justice Kennedy, from the beginning, has always been a critic and a skeptic of affirmative action, but here he is upholding the UT system, the very same system that a couple years ago he wrote the opinion saying, you didn't really look at this very carefully, Fifth Circuit. You need to do a better job and hold them to higher standards. Take another look. Fifth Circuit took another look, said it still looks fine to us, and Kennedy said, okay, looks fine to us too. So, that's one where at a minimum, Scalia, I think, would have made that a 4-4 rather than a 4-3. Death penalty, this is actually Justice Scalia's last majority opinion for the court, so I'm kind of proud of that. I mean, I wish he was still writing opinions for the court, but the Kansas cases, that was the last majority opinion he wrote for the court. And we went up there on a couple of issues, whether the Carr brothers should have been sentenced together or had separate proceedings, and then also a jury instruction issue on burden of proof to establish mitigation that might justify a sentence less than death. Kansas Supreme Court had reversed in the Carr cases and one other called Gleason, finding errors of constitutional magnitude. Supreme Court, written by Scalia, said 8-1. So I think that's pretty notable. 8-1 said Kansas Supreme Court is wrong. And these are not bases to reverse these death sentences. And the reason I think the 8-1 is significant, that includes Breyer and Ginsburg, who are starting to say, well, maybe the entire death penalty notion is unconstitutional, and yet they join this opinion. And Scalia has very harsh language for the Kansas Supreme Court. He says things like their reasoning is beyond the pale. It's sheer speculation. Actually, he says it's the most fantastic speculation or something like that to find errors. And the court also went out of its way to deal with a third issue that it had not granted review of, but that would have been an independent basis for invalidating the Carr sentences. And the court said, well, we didn't grant on that issue, but looking at it, we are telling you, Kansas Supreme Court, even if there was some error there, it could not have made a difference. So they basically were trying to take care of all the issues that they could. So now we're back in the Kansas Supreme Court, where the court recently issued an order asking the parties to brief 20 issues in one of the Carr cases and 19 in the other one. So who knows what they will do with it. But that's an important area. And of course, Scalia would always be a defender of the constitutionality of the death penalty. So again, if you've got Ginsburg and Breyer wanting to re-examine that, Scalia disappears. If you've got a Democratic or more liberal nominee, you may add another vote that says maybe we should get rid of the death penalty. On executive power, the president's immigration order, the court split 4-4, no decision. I think it's fairly safe to assume Justice Scalia would have been saying the president does not have that power. So his absence makes a difference there, although that one's interesting because the lower court decision was the president's order is unconstitutional and is enjoined nationwide. So what happens when they 4-4 is it just leaves in place whatever had come to the court. So that means the nationwide injunction is still in place. So I think the next step is the federal government undoubtedly will try to find an avenue or a venue to challenge that again and get it back to the court when they have a ninth member. But again, if it's 4-4 and that ninth member is Merrick Garland, nominated by President Obama, I know where I'd bet my money on how it's going to come out if it goes back to the Supreme Court. Federal versus state power, there's one case that a little bit complicated, but it was an important case actually for the states. Basically, whether states could be sued in other states' courts or whether they were immune from such lawsuits. I think the court was poised to overrule an old case that said they were not immune and would have granted immunity. But again, Scalia died. It's 4-4. That didn't happen. The religious rights was kind of a mess this year. This is the Little Sisters of the Poor and the other cases where you have religious organizations, not necessarily the churches themselves, objecting to the way the healthcare law works. They give notice if they don't want to provide certain services, contraceptive services and so forth through their insurance plan. The federal government then goes to that employer's insurer and arranges for the coverage. And the religious institutions said that that's still intruding on our religious rights because basically we're complicit in you're hijacking our insurance plan to cover things that we don't want our insurance plan to cover. It's kind of complicated, but the parties argued. Scalia died. The court issues an order that says, well, maybe you could, it was very unusual. So the court proposed its own compromise, and maybe you could do this, this, and this, and that would work for both sides. Why don't you brief that? Tell us what you think of our idea. And the plaintiffs said, well, that might work. There's lots of ways that might work. Federal government says, no, that doesn't really work. And then the court said, in an ultimate opinion, well, now that the parties agree, we can just be done with the case and send it back to the lower courts. So the court didn't really decide anything, and the parties were not agreeing, but the court was stuck, I think, at 4-4, and they just couldn't do anything, so they sent it back for now. It's in the lower courts to try to figure out what's going on. And then in the union case, I think that's one, there's an old case, probably from the late 70s, where the court said public unions could basically compel non-members to pay dues because they're representing all the teachers or all the employees in this public union. So it's not fair that the non-members don't pay anything, but the non-members object. Some of that money will be used for political activities of the union. I don't want to support their activities. It's a free speech kind of argument. But the Supreme Court had said, no, that's fine. It's okay. You can do that. This was a case poised to reconsider that, and I think until Scalia died, there were 5 votes that would have overruled that and said you cannot force people to pay dues to public unions that can then be used to fund political purposes that those people disagree with. But because Scalia dies, it's 4-4. The lower court decision, which just followed the old Supreme Court case, stays in place. So what difference does it make not having Justice Scalia? Will, in a single term, I think there are lots of examples of how much difference it makes. So what if we have Merrick Garland, who by all accounts is a very highly respected judge, former prosecutor, I think was involved in the Oklahoma City cases. He's well respected and probably as moderate a nominee as the Republicans could hope for. But, of course, the Senate has refused to act on his nomination, waiting for the election. And, whether it's Garland or someone else, it's important who fills Scalia's seat, because lots of issues, I think, are in play. I mean, for better or for worse, over the last several years, many of the hot button topics are 5-4 decisions, which means it matters when somebody goes off the court who takes their place. Abortion, well, if Kennedy's gone to the other side, then it may not matter on that particular issue. There may be 5 votes, even if the next justice was another Scalia. On affirmative action, that was 4-3. Did not have a full court. Presumably, Kagan would be on the side of favoring the use of affirmative action, so that would put it at 5 votes. So maybe a replacement doesn't matter other than strengthening a majority in a particular direction. Capital punishment, I think it could make a lot of difference. Again, if Breyer and Ginsburg get their way and get the court to sort of look at the whole enterprise again at some point in the not too distant future, then it matters a lot whether you have a conservative or more liberal justice thinking about that. Criminal procedure is actually one that's interesting. Scalia, he was conservative, but he was also an originalist, and sometimes his reading of original history led to conclusions that people might think of as liberal results. I don't think he would think of them that way, but in particular, rights of criminal defendants, he was very strong on confrontation rights. You get to see your accuser and the witnesses against you face to face in court. So he did not like the use of hearsay evidence. For example, you have to bring the person in so the defendant has a chance to question them. Fourth Amendment cases, he did not like a lot of the modern search tactics of the police, using infrared technology to see if a house is hot, which suggests maybe they're growing marijuana inside. I mean, he was protective of people's privacy. So some of his originalism led to decisions that can fairly be characterized as pro-criminal defendant. But it wasn't because he had necessarily sympathy for the defendant. It was because he thought the founders would not have expected or wanted this kind of state intrusion into people's privacy. Gun rights, Scalia is a key vote. I would think with his replacement, Heller would be at risk, whether there is a Second Amendment right that is individual as opposed to a militia right. That one I think is definitely in play if there's someone with different views than Scalia. Executive power, Scalia, he went both ways. Sometimes he didn't like what presidents did, sometimes he defended presidents' prerogatives, so that one's a little harder to know what a replacement might make a difference. Scalia was generally sympathetic, not always, but generally sympathetic to assertions of state power. So if you have someone who's much more pro-federal government, you may see more erosion, if you will, of state sovereignty and state power. Religious rights, Scalia's a little bit of a mixed bag there. He was strong in the recent cases under the statute, RFRA, the Religious Freedom Restoration Act, but he also wrote a decision called Smith, Employment Division versus Smith, 26 years ago when I was a law clerk, that basically said if you have a general neutral law, government doesn't have to make any exceptions for religious interests. And that was more in government's favor than religious objectors' favor. I'm not sure why he felt that way. It's a decision that several justices have criticized. I'm sure religious groups would criticize. But, Scalia actually being absent on that question might open the door for potentially greater protection of religious rights. Freedom of speech, he was a very strong defender. But, in that regard, who isn't on that court? Maybe Alito is the only one with any common sense when you come to freedom of speech. When the Phelpses went up, there are lots of examples. The guy Alvarez, who was falsely claiming that he won a Congressional Medal of Honor and they wanted to prosecute him. And, Alito seems to be the only one who thinks the government ought to be able to do some things about some of these people. The rest of them, by and large, it's speech. You're protected. So I don't think a replacement for Scalia is going to make any difference on freedom of speech. So does it matter who replaces Justice Scalia? And you've got three possibilities. One is that for some reason, and I'll posit one, Garland gets confirmed, in which case President Obama has replaced Scalia. But if that doesn't happen, then who wins in November could make a very significant difference in who that ninth justice is. And I suspect if Mrs. Clinton wins, Garland probably won't be her nominee, and particularly not if the Democrats win the Senate back. If she wins and the Democrats have control of the Senate, she's going to want somebody much more liberal and aggressively so than Merrick Garland. Now, the Republicans, if she wins and Garland hasn't been withdrawn, might want to approve him, right after Election Day, because he's probably better than anything they're going to get from Mrs. Clinton. Trump has put out a list of people he would consider for the Supreme Court, and it's kind of an interesting list. Most of the people are pretty well known and pretty well respected. Certainly, generally much more conservative in nature. I think he has at least 3 state Supreme Court justices, one of whom is a KU graduate on the Minnesota Supreme Court. So personally, that'd be kind of neat to have a former student on the U.S. Supreme Court. One is a Colorado Supreme Court justice. She's a Thomas clerk. Another one is a Utah Supreme Court justice. He's a Thomas clerk. There is a certain theme here. Some federal judges who clerked for people like Chief Justice Rehnquist and so forth. I mean, his list, he put it out with 10 names, and it would be very, very different than what we'll get from Mrs. Clinton or from President Obama, and much more like a Justice Scalia in terms of the replacement. So does it matter? I think it does, but who knows at this point what's likely to happen. So if you break it down, this would have been a way to kind of describe the division on the court. So certainly you have Breyer, Sotomayor, Kagan, Ginsburg. Frankly, if I was to describe them, I would say Ginsburg, Kagan, and Sotomayor are the most consistently more to the liberal side of the spectrum. Breyer is kind of a quirky pragmatist, if you will, and sometimes he just thinks something's not very practical or workable, so he's actually come over to what you might view as a more conservative side occasionally. Now, other things, he wrote the Texas abortion decision. He's clearly on the liberal side. Roberts, Thomas, and Alito, pretty strongly conservative. Kennedy, I'm not sure he belongs on that side anymore. You know, he's definitely moved. I mean, not only is he the swing vote in a lot of key cases, he seems to be going more the other direction and away from his roots, if you will. So who's there? On a lot of issues, it's going to matter very much, which is why people should care. So I think that's it for my prepared talk, but I'm happy to try to answer or take any questions if you have them.
Q&A now. And as our practice, please ask questions, and we'll go to our members first.
What is the role, responsibility, and privileges of the Chief Justice, other than being the first seat?
Okay, yeah, fair question. They really are, in terms of voting, they are 9 equal votes. So the chief doesn't carry any additional weight. Trust me, the others have no problem disagreeing with the chief if they don't see it his way. The chief does have some powers, though, that are important. And one of those is, basically he presides over every one of their meetings when it's the 9 of them. So in that sense, the chief kind of sets the tone, can to some extent kind of guide what the court is doing and how it's considering things, but ultimately cannot alone decide which issues they get into or how they'll turn out. But when the chief is in the majority, the chief decides who writes the opinion, and that can be a pretty important power. So it means the vast majority of Supreme Court cases, Chief Justice Roberts is deciding who writes the opinion. And the way they do that, certain people, so if you're Chief Justice Roberts, are you going to give, Justice Ginsburg a hot button constitutional case, even if you're on the same side, which is probably unlikely? No, you're not. You're going to give it to Thomas or Alito or somebody who you want their perspective to come through for the court. Sometimes Chief Justices, if it's 5 votes and they think somebody's wavering, they may assign that wavering justice to write with the theory that that will hold them to the side they voted for. So that's probably the most important power the chief has, is predominant in assigning opinions and who gets to write what. He does have other roles. He's actually the chancellor or something of the Smithsonian Institution. By statute, he's in charge of the Smithsonian, and has other administrative responsibilities. But as far as power within the court, the only one that's really of any significance is that power to assign who writes the opinions.
My question is, Supreme Court rules invalidate something, and the president goes ahead and does it regardless, or you overrule what the state has done, and the state goes ahead. What is the enforcement that the Supreme Court has if they're ignored by the other branches?
Yeah, well, that's a great question, and the answer is they don't really have any enforcement power. What they have is the trust and the respect, I guess, if you will, of the American people. If the notion is, okay, the court has ruled, like it or not, we'll accept the decision. That has come to a head at times. So, for example, there's a famous incident, more or less true, from the 19th century, where the court ruled that the Cherokees could not be removed from Southeast United States. Andrew Jackson was president, and the report is that he said, well, John Marshall has made his ruling, now let him enforce it. Jackson refused to. On the other hand, when you get to Little Rock in the 1950s, Eisenhower was certainly not aggressive about integration, probably had mixed feelings about it, but when the court said Little Rock High has to be integrated, ultimately Eisenhower called out the federal troops and made sure it happened, even if he may not have agreed. I think a good example is Bush versus Gore. It's controversial, and nobody will believe that it wasn't political on the court's part, that the D's voted for Gore and the R's voted for Bush. That may be part of what was going on. I actually think part of what's going on is they thought if they didn't resolve it, it was going to go to Congress, and that's like the worst thing for everybody, because Congress can't do anything right, and with all of them trying to figure out who the next president is, that would have been a mess. But what I find notable about Bush versus Gore is, Gore didn't go and try to occupy the White House. I mean, people criticized it, but the decision was accepted, and we moved on. So, bottom line, their authority is basically respect of the other branches of government and of the people to abide by the rulings. But if somebody refuses, they did not and could not stop the removal of the Cherokees. When Jackson refused to do anything about it, the court couldn't stop it.
It's been said that the next president might appoint as many as 3 Supreme Court justices. Which positions do you see that being?
Yeah, no, that's a fair point. So if you look at this group, you've got Ginsburg in her early 80s, probably 82 or 83. You've got Kennedy and Breyer approaching 80. I think 78 or 79. So those would be the 3 primarily that people would be talking about. So if you think about that, well, if Ginsburg and Breyer go, and it is a Democratic president, it's not going to make any difference. They're just going to replace them. But on the other hand, if they go and it's a Republican president, it's a chance to put another Scalia or somebody in their place. The one that's going to be the big fight, if things continue as they have, is likely to be Kennedy. Because he has been a central figure in a lot of the 5-4 cases. Now, he may be taking himself out of that as he becomes more liberal. But I think if the first vacancy were Kennedy, it's going to be a big fight, and it will matter a lot. If it's a Democratic president and it's Ginsburg or Breyer, you're just going to get somebody like them, and it won't change the vote. So in terms of what issues get affected, I think definitely abortion could be in play, affirmative action could be in play, gun rights, I think, absolutely could be in play under Heller. So, all of those, as well as just generally views on federal power. I mean, one of the things I don't like about this court is it's sort of become the situation that most justices have been in the federal government and federal judges before they get on the court. And I think that has a tendency to federalize them in a way that the states, it's not to our advantage, and I don't necessarily like it. The chief is a good guy, but he's no help on what are called preemption cases, whether federal law preempts state law, because he spent his whole career basically in the federal government and private practice, so he's comfortable with, well, the federal agency or the federal Congress is doing this. Does it preempt state law? Yeah, that's fine by me. That's not the view I would like to see. But as long as they follow that model, there is kind of a federalizing and a more of a sympathy, I think, for federal power than many of the states would like. So I'd love to see them go back to take some state Supreme Court justices or, a state governor, a state AG, somebody who has both political experience and more of a state perspective.
How does the court decide which cases to take?
So what happens is the parties, so you get a decision in the lower court, you don't like it, you file what's called a petition for a writ of certiorari. Now, I say certiorari, there's actually been articles written apparently all 9 justices say the word differently. So I don't know if it's certiorari, certiorari, whatever you want to, but you can read an article and there's arguments about how do you actually say the word. But in any event, they are petitions that say, and what you do literally in the very front of the petition is you say, here's the question or the questions we are presenting to the court. So you don't just sort of throw here's the whole case. You say, the question in this case is, was it constitutional error to try these brothers together in their capital sentencing proceeding? I mean, you're fairly precise about what the issue is. And sometimes you can have more than one, and sometimes they will grant only one, not others, 2, not others. So you send that into the court. The other side has a chance to respond. You get a little reply, and then it goes into a system, by and large, that is the pool system. So what started happening under Berger way back in the 70s, there's so many petitions coming in. If each justice tries to look at 9,000 petitions, that's a lot of work. So what they start doing is pulling the law clerks. So every petition will get a memo written by a law clerk, but it might be me writing the memo that goes to all the justices. It's not just for my boss, so that's the cert pool process. So every case gets some individual examination, but those memos go out, and then they meet on average probably 3 times a month during the term where they can consider cert petitions, and it takes 4 votes. So you've got to have 4 justices say, yes, we will hear this case, this issue. So you don't have to have a majority, but you do have to have 4. And that's another area, I think, where Scalia's death will make a difference, because he was fairly aggressive. He knew certain issues he was interested in, he wanted to address, he was looking for cases. You know, right now you're down to 8. So just statistically, it's harder to get 4 votes out of 8 than it is 4 out of 9. But you also lost an active justice who really looked for things and wanted certain kinds of cases to be decided by the court. But that's how it works. So when they go to the conference, there's more to the mechanics, but basically they'll have a list of what I'd call the cases they're seriously considering, and they may actually vote on those, going around the table again. The vast majority, they don't actually take a vote. If no one expresses interest in a case, which is often true, it's just automatically denied after that conference. But if anybody says, I want to talk about this one, then they will take an actual vote on that case.
How unusual is it for one of the justices to travel without security?
It used to be common. It used to be very common. A little less so now, although I think a lot of them still, what happens is the Marshal's service is their security. The Marshals work with the judicial branch. People often think, oh, it's the Secret Service. Well, with the justices and the judges, it's the Marshals. But the Marshals often gate to gate them, is my sense. So the Marshal will be with them literally at the gate. The justice boards the plane. There will be a Marshal on the other end at the gate when the justice gets off. But the Marshals don't necessarily fly with the justices. Now, once they're on the ground, there's going to be security for anything quasi-official. So if they're visiting a law school, speaking to a bar group, they're going to have that security. Now, Justice Thomas, he has a great big old bus. I call it a country music bus. It's one of those kind of, it's the shower, the kitchen, the bed, the whole thing. And he'll drive that thing around with Mrs. Thomas, and there's no marshals going with him. He's just off in some KOA campground somewhere in, as he calls it, real America, enjoying the people and out there on his own. So, they do take private trips, and they don't necessarily have 24/7 security, but they have a lot more than they used to. The last time the chief visited KU in Kansas, 3 or 4 years ago, and they brought bomb sniffing dogs, and they would, so before he'd go in a venue, they'd run the dogs around before they let him. That didn't used to happen, so they're a lot more security conscious than they used to be.
Last question.
So thanks again, Professor McAllister, for coming. You clerked for Justice Thomas, and he famously did not ask questions from the bench until recently. So do you think something has changed, or has he just warmed up?
No, I think Yeah, a fair question. Nobody knows really why Justice Thomas doesn't say much on the bench. You know, when he was on the lower court, he did. When I was law clerk for him, it was his very first term, and he asked some questions that term, but over time he kind of became silent. And if you asked him why, I've heard various explanations, so I don't know which ones, if any of them, actually the real reason. He says things like when he was growing up, people made fun of his dialect, so he's always been a little self-conscious. Or he says things like, my colleagues talk too much. You know, the lawyers can't get anything out. There is some truth to that. I mean, he'll say, any question I might ask, somebody will ask during the course of the hour. So, you know, I just try to let the lawyers do the thing. I don't know, you know, what his real reason is. You know, what I will say before I answer why is he talking now, perhaps, is he is fully engaged. He's read everything. I was very impressed by how quickly he grasped and was up to speed on things. I mean, he was ahead of the law clerks most of the time when we'd sit down to talk about cases, bankruptcy, tax, whatever. I mean, he had it figured out. He understood it better than we did. And, you know, if you read his opinions, they are very thorough and thoughtful. So he's fully engaged. He just doesn't, for whatever reason, seem to want to talk at oral argument. So to the extent the press says, oh, he's, you know, not smart enough, or he just doesn't care, or he doesn't know what's going on, that's all just, you know, BS. I mean, he's very engaged and very smart. But his recent talking, I wonder if we won't see him speaking up some when there's an issue that he thinks Justice Scalia might have led the charge on, and that voice is gone. Because unlike Thomas, I don't think Scalia ever had an argument in which he didn't talk. You know, he always had questions and comments, and sometimes Scalia, you know, I knew he didn't care what somebody was saying because he knew what he was going to do, but he'd be pushing them and arguing with them and asking questions and making jokes. He just liked to talk. But, you know, the case where Thomas spoke up most recently was actually about gun rights, and he was asking under federal law if there was any other right that you could lose for conviction of a misdemeanor. And I think the answer is no, but he was pressing the government lawyer on that kind of notion that how can you take away the right to bear arms based on conviction of a misdemeanor, not even a felony. So, you know, that's the kind of thing Scalia would have been interested in. So I could see him speaking up some when he sees, you know, Scalia's voice is absent and he would have said something here and Thomas wants to hear the answer, particularly from the government. I could see him pressing the federal government a fair amount.
Professor Stephen McCallum.
Oh.